Mr. Burnell.
Thank you, Senator Blumenthal, Representative Garcia, and the members of the committee, both for your leadership on immigration issues and for giving me an opportunity to speak with you today. My name is Steve Burnell. I was the General Counsel of the Homeland Security Department from 2013 until 2017. I previously had served 17 years as a career federal prosecutor, including several years as the chief of the criminal division in the U.S. Attorney's Office here in Washington, D.C. I am one of 6 former general counsel and acting general counsel of DHS who recently co-authored a guest essay in the New York Times disagreeing with ICE's new policy of relying on administrative arrest warrants to forcibly enter private residence to arrest someone for a civil immigration violation. The 6 of us included top DHS lawyers from the Bush administration, the Obama administration, the first Trump administration, and the Biden administration. This is a group that doesn't agree on policy issues always, but we all agreed on this point. The judicial warrant is a requirement of the Fourth Amendment, and it applies to ICE just like it applies to every other federal, state, and local law enforcement agency. What also united and frankly offended all of us who signed that New York Times op-ed was the current general counsel characterizing career DHS lawyers as, quote, deep state operatives with some sort of hidden agenda to undermine the department's mission. This is a cheap shot, and it's wrong. It's not the so-called deep state that for decades has kept ICE from entering a home using just an administrative warrant. It is the Fourth Amendment of the Constitution and the lawyers who took an oath to support and defend it. During our time at DHS, the 6 of us worked with thousands of DHS lawyers. Those lawyers sought to ensure that DHS's actions are lawful and to protect the constitutional rights of the people DHS agents encounter during operations. To smear career lawyers as deep state operatives for giving legal advice that is faithful to the Constitution is not only offensive, but also dangerous. It sends a message. If you give your best professional advice and urge the department to respect the law, you will be attacked for doing your job. It is a basic principle of the Fourth Amendment that searches and seizures inside a home without a judicial warrant are presumptively unreasonable. Indeed, as Mr. Schwenk just said, the Supreme Court has stated that the physical entry of the home is the chief evil against which the working of the Fourth Amendment is directed. The law is also clear, as Representative Garcia pointed out, that, the law is also clear you can't enter someone's home without a warrant that's been issued by a neutral and detached magistrate or judge. In other words, the police can't sign their own warrants. This is a basic check and balance against tyranny, and also a recognition that in the competitive enterprise of law enforcement, even a good, well-intentioned police officer is subject to the natural human biases that we all share, and therefore needs the approval of a neutral and independent judicial officer before taking an action as consequential as a forced entry into a person's home. And as Representative Garcia noted, it's important to point out that in the context of immigration enforcement, the Fourth Amendment says the people have the right to be protected from unreasonable searches and seizures. It doesn't say citizens, it says the people. It's thus well established that the Fourth Amendment applies to everyone within the physical boundaries of the United States, including immigrants who are not lawfully present. ICE claims that its general statutory detention authority combined with a final removal order by an immigration judge is sufficient to satisfy the Fourth Amendment. But that argument doesn't work. Immigration judges are not neutral and detached judicial officers within the meaning of the Fourth Amendment. They work for the executive branch and are subject to the control of the president and the attorney general. Immigration judges also lack the statutory authority to issue warrants, either for an arrest or for a search. I'm happy to flesh out these points and others during my testimony. In closing, I urge the Homeland Security Department to adhere to the Constitution and to end the un-American practice of conducting forcible entries into homes without judicial warrants. Thank you.
Thank you, Mr. Burnell.